evidence, may I assume that can be deleted since
Yes.
there's no videotape depositions, so that will be stricken. And the parties had included a stipulation regarding the defendant's blood sample and chain of custody. Should that still be in there?
I think we can take that out.
Okay, does the state agree?
Yes.
That's what I was thinking, but I didn't want to just do it. So, okay, so that stipulation will be eliminated. The state had included, at least in its initial proposed jury instructions, a request for a false exculpatory statement instruction. Is the state still requesting that?
No.
Okay, then that won't be included. We'll strike that as well. And then there may be other issues, but let's get to the subject matter that we discussed this morning concerning the parties' competing proposed jury instructions regarding the charges that are no longer before the jury, referring to the 7 negligent homicide in consequence of being under the influence of drugs or any combination of drugs, and the 1 aggravated driving under the influence indictment. The parties have submitted proposed instructions. The first paragraph of each is generally similar. The wording's a little bit different. Before I get to the scope of the second paragraph, is there anything either party wants to say about the competing language of the first paragraph? Attorney, who's handling this for the defense? Merkin?
Yes, I am, Your Honor. I don't think we have any particular difference between ours and the state's
Okay.
as far as the first paragraph.
And Attorney Speicher?
No, Your Honor, I think the only difference is references to charges rather than indictments, and that we draw it first.
Okay. And whatever I do, it was the clerk who read it, not the deputy clerk, so I'll strike deputy, but other than that.
All right.
So with respect to the second paragraph, the first sentence is generally similar, though not identical. It seems to me that the principal dispute has to do with whether I include the second and or third sentences in the second paragraph that the defense is proposing. So, Attorney Speicher, if you can articulate the state's objections to that additional language in this proposed instruction?
Yes, Your Honor, I think the language the state proposed appropriately captures the meaning and intent of what this instruction is supposed to do. I think those extra sentences are cumulative. I think they're unnecessary. I think there's a bit of editorializing in there. The jury does not need to be instructed. And again, in this context, it is up to them to determine guilt or innocence. That is a separate issue, and they are going to be so instructed. They're going to be well aware that the entire case sits with them. I think the point of this instruction is to tell them that evidence regarding impairment and drug use there is not to be considered by them. So I think that's all that needs to be said.
Okay. And Attorney Merkin?
Your Honor, if we were talking about one fairly small point of evidence, we were talking about the witness who said something about crack pipes, it's 1 sentence, and a 1 sentence or 2 sentence instruction is sufficient to tell the jury, yeah, forget about that. This is something that dominated the first week plus of the trial. A substantial amount of the evidence presented by the state, including almost the entire second interview, the June 24th interview, was focused on the issue of drugs and impairment. And the reason we submitted what we did, which emphasized and made much clearer what the court is instructing the jury to do, is I think it's necessary to impress upon the jury that they heard an awful lot of evidence about that, and they are not to consider that evidence, based on the state's representations yesterday, for any purpose whatsoever. And that's why we added those last couple sentences to emphasize that, because given the volume of testimony, including the whole afternoon, I think, with an expert whose entire testimony was about this issue, I just think it is necessary to emphasize it more than you would just with a one-sentence instruction for one small piece of evidence that's being kept out.
Okay, I will contemplate that. My only other question, then, I'll let the parties provide input to any objections they may have to the other instructions. At one point, at the outset of the case, the state had indicated that it might like to have the court employ a special verdict form for the jury's use. Is the state still requesting that?
I don't think that's necessary at this point, Your Honor.
Okay, me either, so that works for me. Then in that case, Attorney Spicer, with respect to does the state have any other objections to the jury instructions that the monitor submitted, or provided counsel several weeks ago?
I don't believe so, Your Honor. If I can just check my copy, I think the court addressed everything. One other thing that would be worth raising in the discussion of manslaughter, and I suppose this might be in the negligent homicide as well, there's a paragraph about if voluntary intoxication made the defendant aware. I don't know if the defense counsel has thoughts on this.
Oh, yeah, we definitely would be asking to strike that. It's in the manslaughter and the recklessness definition, it's not negligence.
Yeah, it's standard in it when it applies, and at least based on the charged conduct it applied, but I would strike, so that's on, at least in my copy, page 13. If the defendant created a risk but was unaware of the risk solely because he was voluntarily intoxicated, that paragraph will be stricken?
Yes, and I would just note it may appear in other portions of the instructions, where it appears we would be okay with that.
And
I don't.
okay, I'll double check. I think that's the only place it appears, but if defense counsel identifies anywhere else that appears, counsel may so advise me.
And see if there's nothing else.
Okay. Attorney Dugay, does the defense have
So,
objections to the proposed instructions in any respect?
yeah, we do, Your Honor. I have it on page 12, but maybe that's just a pagination issue. So,
You have what?
the voluntary intoxication, is that,
It could be because we've added the stipulations, so that it's the next to last paragraph in the manslaughter instruction.
okay, yeah.
The voluntary intoxication paragraph in mine appears just be above the paragraph that reads, whether the defendant acted recklessly is a question of fact for you to decide. So yeah, your pagination may be a little different because the monitor added those stipulations that you provided me with during the middle of the trial.
The only other issue, Your Honor, is with the definition of causation that's been included. I know that we had some prior discussions about that and submitted the proposed instructions from both parties, but now that we've heard, some of the evidence, I think it puts into a better context. And we'd be asking that the court include the language from State v. Seymour that the cause must be more than a mere possible cause or a contributing cause. So it's 140 New Hampshire 736.
And was that in your proposed instructions?
I believe it was, Your Honor. I don't have that pulled up right now, but
I'm pulling it up, but. You're referring to the section on page 1 of your proposed instruction on causation. It must be more than a mere possible cause or a contributing cause. The cause must be a direct and substantial factor in bringing about the death or injury.
yes.
So that, you want that sentence, and you want that sentence inserted, hold on a minute. I assume after the second sentence of the instruction that I've indicated, a legal cause is a cause without which the event would not have occurred, and the predominating cause, a substantial factor from which the event follows as a natural, direct, and immediate consequence, and then you would want me to insert that additional sentence there?
So, Your Honor, the way that, essentially, correct, so where I'm trying to find it on these.
What page is it on?
In mine, it's in the second paragraph of the charged offenses under manslaughter. It's beginning at charged offenses. The first paragraph enumerates the elements, then the second paragraph explains causation. And then it would appear, based on your proposed instruction, that we are contemplating I insert that sentence, if I am to insert it, would be after the second sentence, which ends with, as a natural, direct, and immediate consequence, in my instruction.
That's correct, Your Honor, and I think that's supported by State v. Seymour. That language is included in State v. Seymour, and the court, in reviewing the sufficiency of that instruction, the court said that the supplementary instruction in the context of the record and the entire charge accurately conveyed to the jury the burden to prove the defendant's direct causal involvement in bringing about the deaths of the victims, while requiring the jury to acquit the defendant if his actions was a mere possible cause or contributing cause, or less than a direct and substantial factor. So I think that's the Seymour instruction, and that the concern was accurately conveying that principle of law. And then in State v. Lamprey, Your Honor, that's 149-364, they were reviewing the same causation, or they were reviewing the causation instruction given in that case, and they said, while the language in Seymour is preferable, this also adequately conveys the appropriate legal concepts, and that language also included the language of not merely a possible cause, but a contributing cause. It must be the predominant cause.
Okay. And is that the only objection or request that the defense has?
That's correct.
Okay, so Attorney Chase, what's your state's position on that proposal?
Yeah, the state would object, and again, we didn't realize we were reopening it to that. I thought that part of the instruction was established, but the state would again fall back to the model instruction, which was based on SUSI, which has been used since. I think if you look at the first statement in State v. Santil Brown, 172 and 110, characterizing what the law on causation is. I mean, that's the case with the mother. It was she spent 5 days before calling firefighters, and the victim died 3 days later of meningitis. But I think the law on causation is clear, and I think read together and jumbling that in there is confusing the issue here. So the state's position is that the model instruction is the instruction that should be applied, and that the current proposed instruction from Your Honor more thoroughly explains and expounds upon the sole substantial factor beyond model instruction as it is. So for those reasons, the state would either say defer the model instruction or to Your Honor's current instruction.
Attorney Chase, if I were to deny the defendant's request to add that sentence to the instruction, would it still be permissible for defense counsel to argue the substance of that sentence in its closing?
Frankly, yeah, I think they can argue that. I think that Your Honor's instruction characterizes causation exactly how the law in New Hampshire is, and as I said, the model instruction from 2010 was based on State v. SUSI. It was drafted based on State v. SUSI, and I think Your Honor's instruction goes beyond that in clarifying that, so I think that's sufficient addresses causation.
Attorney Duguay, anything further you wish to say on that issue?
Just briefly, Your Honor. State v. Seymour and State v. Lamprey were both decided after State v. SUSI. They've added additional judicial interpretation of what the state of the law is with regards to causation. And I think that obviously the facts of this case indicate whether or not the defendant in this case was the predominant cause of this accident is obviously a substantial issue. And I think additional language consistent with Lamprey and consistent with Seymour, giving a little bit more information about what it means to be a predominant cause is appropriate and important given the state of the evidence in this case.
I can just clarify one point on that.
You may.
I'll go. All of the cases that we're talking about, as far as Stacey Seymour, Stacey Lamprey, all of those were before the model construction was drafted in 2010, 10 years before. And those cases since, again, as I said, St. Brown gives a pretty direct statement of what causation is. And as I said, I think the model instruction is on point with the state law, and as I said, I think Your Honor is as well, and goes beyond the model instruction.
Okay. Then I will take that request under advisement and decide what to do. Anything else to address regarding jury instructions?
Not jury instruction.
No, Your Honor. But we did have a discussion about removing exhibits, and I don't know if you want to address that now.
I know the parties were conferring about that to some extent, but if there's some things I can decide or assist with, I'm happy to do so.
At this point, I don't think there's any judicial intervention necessary. We've agreed on a number of exhibits. The state's going to look over the June 24th interview exhibit over the weekend and let us know what, if anything, they think is still relevant to that, and we can discuss that at that time.
Okay.
There's one more.
Attorney Chase?
Yes, the Trooper Gerardi video that we entered, there's no objections over foundation. However, because it's a video, we can't, I talked to my paralegal, we can't redact. As Your Honor may have seen, there's some American flags in the background. It's not before the litany of them were placed there, but there's certainly flags in the background. The state's purpose in introducing that is it actually covers some of what Mr. Howerton is going to be talking about as a very specific area of the roadway. It is taken in the daylight, it is taken close in time, and it clearly shows that area of the roadway. So it has any tendency to prove, and I don't think a few American flags at a distance are substantially outweigh the relevance.
Attorney Duguay?
Your Honor, I think the video is cumulative of the photographs and the other videos that we have played. Everything that was in that video is clearly covered by photographs. And I actually think, Your Honor, that you know, I'm assuming what the state's arguing or planning to argue with respect to that video is that some of the markings in the roadway are not visible in that video. It's a cell phone video panning across, and so it looks like some of those markings aren't necessarily visible. However, they are clearly visible in all of the photographs taken from the day of the scene. There's plenty of evidence as to what that scene looked like on the day of the event. This video was taken days later. It doesn't accurately reflect what the scene looked like on the day of the event. Everything had been removed from the scene. There were pieces of evidence that were no longer visible. There was quite a bit of evidence that's no longer visible. And it's cumulative of other videos that the state has presented. There's been videos from other people that were at the scene at the time of the accident. So it's cumulative of the evidence. It's also misleading because we presume that the state is going to use it to argue that the marks relied upon by Mr. Howerton weren't visible. However, they're clearly visible in the photographs taken by the state police on the day of the event.
So the defense objects to the video in its entirety, not just to the depiction of a few American
Correct.
flags.
As well as the flags, Your Honor, that's also problematic. I think that we have multiple areas of potential prejudice from the flags, from the sort of misleading nature of the video, and the cumulative nature of the video, and limited relevance given when the video was taken, what type of video it is, what it shows. I think that any probative value of that video is substantially outweighed by the danger of unfair prejudice.
So for what purpose or purposes would this video be offered?
So it would be offered to show not only the lack or marks that may not be visible or not clearly visible. It also shows lack of other marks that would be consistent with Mr. Howard's theory. The other videos, as Your Honor saw, are videos of really the destruction and the amount of destruction. This is after the videos were removed, or after all of that was removed. And unlike the UAV photos from the drone, we know that there was attempts to take drone photos that night, but unfortunately, that was the first night flying at night, so they came out terrible. But when they took the daylight photos, it was a week later. Everything defense just said was weight, not admissibility. As far as cumulative doesn't prevent the state from providing similar information. This is from a different angle. It's actually walking up directly to the point where Mr. Howard won't be talking about. So to the extent that defense wants to argue that those marks would have been visible at that point and everything else, that's all weight, not admissibility. And the flags as far, I made my 403, I just don't think flags.
How long is this video?
2 minutes.
2 minutes?
It's less than 1 minute.
1 minute.
Can you play it?
Yeah,
You want me to rule on its admissibility? Let me see it.
We thought we sent it back with you, Your Honor. I apologize. We can actually throw it up on your screen.
Sure. So those will be on my monitor?
It should.
Okay.
Your monitor on for blue light. Your Honor.
No, of course not.
May I approach?
Red light.
May I approach?
You may.
Oh, okay. And Your Honor, the state will redact the audio. Not that there's anything overly prejudicial, but I don't think there's anything.
So it's just the video that the state proposes to admit.
Correct, Your Honor.
It's blue now, so we're heading in the right direction.
What's the green line stuff?
It's broken. Yeah.
We had it the other day, and then
And are the flags that the defense finds objectionable, the ones on the right side of the
It'll be on
screen?
both
No,
sides.
you'll see, there.
And now
flags and
again?
memorials.
And this was taken on what date?
This was, Sunday the 23rd.
At about what time?
I can tell.
Looks like
Been
afternoon,
It was mid-afternoon, Your Honor.
based on the shadows.
Correct. I just don't like to give the exact answer.
That was it. And the principal purpose for which the state wants to offer it is to the jury to see the either markings or absence of markings on the road on June 23rd?
Correct, and to obviously inquire to the defense expert about various markings and lack of markings that are on the road. And again, we're talking about any tendency to prove a fact that's an issue, and this is certainly going to be a fact in dispute, and I think otherwise it's a weight, not a disability. If it helped, I could look at the video and see if I can cut out maybe that first 10 seconds so that the first view of the flags is there to help minimize.
There's two views. There's one that flashes right and one that flashes left. That was going to be, I mean, if and to the extent that I agree that the video is admissible, but that the flags may be unduly prejudicial, can the depictions, can those portions where the flags are depicted be glossed over, redacted, eliminated or something? So, I mean, what the state wants to show is the road and the road markings, so.
What I might be able to do is cut it so that when he turns left and starts coming right, I can have it kind of start there when he's panning. But there's probably no way to get every flag out of the photograph. I don't think, or out of the video frame, because I think even at the end there was flags. But I could probably eliminate that first view of where the truck came to rest and those flags there. I think probably do that pretty easily.
Okay, I mean, I was watching it in real time, but it seemed that if I was going to allow it, you could eliminate the first scan to the right, and then you could likewise eliminate the scan to the left. I mean, you go as far as the edge of the road and the road markings, and don't show the flags on the shoulder of the road.
Yeah, I can do that. I'm thinking off memory, I can play it again, but I think that even in that final frame where he's looking at that area, I think there may be a flag that's still in view. I also, for additional relevance, I think it also shows a pretty clear view of what the perspective would have been from the motorcycles at the time, the angle and everything else too. So I mean, there's certainly relevant evidence here to the extent that the defense claims it doesn't accurately characterize it. That's absolutely argument and cross-examination or redirect from Mr. Howerton, but I think if we can cut out substantially all of the flags, and especially that last scan back towards the site, there's certainly no 403.
Attorney Duguay?
Your Honor, I certainly disagree with that, and I think the state's assertion that it's weight non-admissibility ignores that sort of the weight of the evidence is part of what the court's weighing in the 403B analysis. So how significant is the probative value of this evidence as opposed to the potential for unfair prejudice? That's part of the analysis. And so in light of what this video represents, which is the scene, more than 48 hours later, after thousands of cars potentially have driven over the evidence, there's also other markings on the roadway that are problematic because there's no testimony about what those represent. There's blue spray paint everywhere that was done by somebody. We don't know who, or we don't know what those represent. There's also the flags are obviously, I think you understand the issue with that. But there's plenty of accurate roadway evidence and photographs taken that would show everything that the state wants to show. That the perspective of the vehicles in each direction, the scene, the evidence, everything else, and the ones that would not have a tendency to mislead the jury into finding a lack of roadway evidence. Because I can show you, Your Honor, what we're talking about. There's several photographs of that exact same area that show all the things, and there's hundreds of photos the state has exhibited, but this is the exact area of that. That's Exhibit J, Exhibit K. This is just our exhibits of on the day of the scene, the exact photos of the exact area that the state wants to show. Now, what they want to show is a cell phone video that I think, with the purpose of specifically misleading the jury into believing that certain marks in the roadway that are relied upon by all experts in the case, well, not all of them, but by some of the experts in this case, that...
By which? Mr. Howerton, apparently. Who else?
Well, Mr. Howerton, and I think that in depositions, crash sites acknowledge the existence of those, although they disagree about what they represent. They certainly acknowledge the existence of the marks. They acknowledge that they were placed accurately in Mr. Howerton's photogrammetry solution. And so I think that allowing the state to put a video up and say, oh, look, you can't see these marks in this cell phone video taken 2 days after hundreds or thousands of cars were driven over the scene, shows that those marks didn't exist, when in fact, we know that they did. And so there's prejudice in allowing the state to present evidence that's misleading in that regard. And for the purposes that the state specifically said, they want to show that marks didn't exist when they clearly do with these photographs. And so there's certainly no suggestion that the photographs were altered by anybody. And so we need this evidence to prove that those were actually not there. I don't think the state is going to debate that some of these marks were present. So the simple fact is we have accurate information about everything that the state is suggesting is relevant about this video that was taken on the day of the accident, not days later when evidence has already been compromised. And I think allowing the compromised evidence in front of the jury is misleading. It can confuse the jury as to what the evidence was on the day of the incident, and that's clearly prejudicial on top of the flag issue. And so the probative value, again, Your Honor, is very limited because there's plenty of other evidence that the state has that can accurately portray everything that they are claiming is relevant about this video.
Ms. Boyer, what exhibit number is this? What exhibit number is this little video? Has it even been marked for ID yet?
216? 216, I believe.
216?
Yep.
216.
Attorney Duguay, how many marks are depicted in the photographs from the day of the accident that do not appear in the June 23rd video?
Hundreds of them, Your Honor. But, I mean, you can, if you scan through that video, you can look at if you look at the photographs from the day of the incident, there's hundreds of markings that aren't visible in that video that were marked that were included in the photos, included in other evidence. And so I think that what you see in that video is extremely limited with respect to what was actually present on the day of the incident. And again, there's hundreds of photographs of that scene documenting everything and that can accurately depict the scene. And it is unfairly prejudicial to allow the state to introduce evidence or photographs or video taken days later when that evidence isn't present, and then allow them to argue that the lack of evidence in this video somehow calls into question experts' reliance on the existence of that evidence when it's present in the photographs. And so I think it's a for what the state's suggesting it's relevant for, which is to show a lack of evidence in the roadway, then that's a deliberate attempt to mislead them because they know that some of that evidence is present. And I would note, Your Honor, that to the extent that they show that a lack of evidence of other things that are maybe not depicted in the photographs, basically the photographs will show what is and what isn't there at the time of the accident. There's no need to show a misleading video that was taken 2 days later for the purposes of showing what was there and what wasn't there at the time of the accident.
So Attorney Chase, are there, quote, hundreds, unquote, of road markings that are depicted in the photographs from the day of the accident that are not visible in the June 23rd video?
I don't think any party has looked at that video and counted the marks that are not.
Are there numerous ones?
I couldn't tell you. I mean, Your Honor, what we're talking about here, their expert is saying that this motorcycle was slammed to the right at that spot, in pieces of metal ground into the pavement and slid across the road. That's their theory.
And that's based on markings that, among other things, markings that appear in the photographs taken from the day of the accident?
Correct. And Mr. Howerton has specifically taken some of those photographs and enhanced the brightness because he acknowledged that the lighting was not good when state police took those photographs. It was in the afternoon, it continued to get darker, the photographs got worse. Unfortunately, state police did not keep the scene that night and come back and take it the next day. This is the closest in time. It's not an attempt to mislead the jury. We're talking about weight, not admissibility. Again, courts across this country have let in grainy photographs of defendants, of vehicles. It's a weight, not admissibility. It's not misleading to show a video of the trooper. There's no question that video was authentic. It was not altered. He walked out, he took the video, he walked back. To the extent they want to point out that other marks may no longer be present or that cars ran over or anything else, sure, that's fine. But that doesn't outweigh the relevance of the evidence. And there's certainly no 403 to the evidence that's actually viewed. To the extent there was a statement about blue marks, I think we entered 12 UAV photos. There's blue marks in that too. I mean, that's the fact of the matter is, this was the closest time in daylight that we have of the evidence of the exact area where their expert is claiming a motorcycle slid sideways, ground into the pavement towards the yellow line. There's not a single tire mark or any leftover mark.
But they were in the photographs
But
taken on the day of the accident?
There's 3 marks in the photographs that are there that experts will dispute about what those mean.
But they were there. I mean, the marks were there, that's undisputed?
Correct. Those,
Okay, so I guess, let me ask the question the jurors may ask, where'd they go?
That's great.
So-
That's the point.
So, Your Honor, we're referring to these
straight marks, track bed and river.
So you're referring to this scrape mark, and this scrape mark? If there's actually three, maybe it's two?
Yes, sir. And I believe that photograph, and I'll defer to Attorney Dugan, but I believe that's one of the enhanced ones from Mr. Howard, the bright ones.
What time of day was that taken on the 21st?
About 7:30, 7:45.
I mean, it's
I don't.
daylight, I mean, granted, I mean, it's literally the longest day of the year, correct?
Yes.
Or just about.
But I mean, Mr. Howard didn't even testify at deposition, that was deposition here, but that it's hard to see the marks in the photographs. And he didn't go to the scene. That's what he based his, and he did review those videos, Trooper Girardi's videos
He didn't review the video that you,
that I just introduced. And so he didn't review some of the videos documenting the roadway evidence taken 36 hours after the crash. Now, again, to the extent the defense wants to argue that those marks could have been marks from a metal scraping the roadway, could have been driven over to the point that they disappear, that's great. That's cross-examination. That's not misleading the jury. Misleading the jury is stating something that doesn't show. Showing a video of the trooper saying, I'm here 36 hours later, I walk out, this is what it looks like now. Now is a question of what that means to the jury. That certainly doesn't lead to any impermissive.
and through what witness would the state, well, how's this video getting introduced?
It's already introduced, Your Honor.
Oh, it is?
That's the video that we said we agree on foundation. We just wait for
Okay.
publish, 'cause I knew that wouldn't be required a little more discussion.
Pardon me?
I thought we'd probably have some discussion, so.
Okay. Anything further at this point, Attorney Duguay, on the
No,
video
I think-
issue?
I think the court has a handle on the issue.
Okay, all righty, I'll take that under advisement and make a ruling in due course. I mean, you'll need a ruling before Monday, because you need to
Correct.
know about how to handle Mr. Howerton.
And maybe I think they're calling our reconstructions in the morning, so we may need that video.
McAllister?
Maybe that one
Wi- Pardon me?
That's currently the plan, Your Honor.
Okay, so if you can clue me in, who will the defense be calling Monday? If you can tell me without betraying trial strategy?
No, it's fine. We've been sharing our witnesses with the state the day before. At this point, and that may change, the plan is McAllister and Howard. And, sorry, and
Holly Coulter
Holly Coulter.
and Trooper Corbally.
Okay, all righty, very good.